Was a woman's body simply a valuable possession, ripe for acquisition? Did the medieval world truly believe a king's right to his wife extended to claiming her very essence, her virginity, her future? Let's be honest, the stories aren't pretty. Forget dusty legal codes and pious pronouncements. We're diving into a world where shadows danced with accusations, where a vanished maiden was a kingdom's crisis, and a stolen kiss could trigger a bloody feud. It began, predictably, with the law. Not the kind you find in modern textbooks, mind you. This was the Decretum of Gratian, a sprawling, chaotic collection of rulings, whispers, and outright guesswork compiled in the 12th century. Imagine a librarian's nightmare, a mountain of parchment overflowing with conflicting opinions, papal decrees, and snippets of Roman law. Gratian, bless his organized soul, attempted to tame the beast, to create a single, authoritative guide to church law. But the beast, as it turned out, was remarkably resistant to order. The core of the problem, raptus. It's a word that sounds vaguely sinister, doesn't it? It's Latin for snatch, seize, but in this context, it meant something far more complex: the abduction and rape of a virgin. Not just any coitus, mind you. This had to be a forceful taking, a violation accompanied by the removal of the woman from her home, a deliberate act of theft, both of her body and her future. The early commentators, a bunch of brilliant but utterly obsessed scholars, dissected this concept with terrifying precision. They argued, debated, and meticulously categorized every nuance, every possible variation. Think of it like a medieval version of a particularly intense game of chess, except the pieces were women and the stakes were their very souls. One particularly sharp-witted commentator, Bernardus Papiensis, laid it out with chilling clarity. Sometimes it is not the thing itself that is seized, but the use of the thing. He wasn't talking about a stolen sword. He was talking about a woman's body, her ability to bear children, her very essence forcefully claimed. Sometimes the use of the thing is not seized, but the thing itself. He was describing the abduction, the theft of the woman's person, her right to choose her own destiny. The Roman lawyers, those pragmatic thinkers of the ancient world, had a concept called raptus too, but it was a far simpler affair, a straightforward theft of property. The medievals, however, layered on a whole heap of moral and theological baggage. Suddenly, it wasn't just about stolen goods, it was about corrupted virtue, the disruption of the natural order, and the potential downfall of an entire kingdom. This is where the church stepped in, and let's just say they weren't shy about wielding their authority. Canon law, the body of rules governing the church, developed its own intricate system of raptus, largely overlapping with but distinct from secular law. It wasn't a simple case of law versus religion. It was a complex, intertwined dance of power, morality, and deeply ingrained societal beliefs. Theologians, those ponderous thinkers who spent their days wrestling with the mysteries of God, had their own perspectives. They saw raptus not just as a crime, but as a spiritual wound, a violation of the woman's inner sanctity. The sermons and penitentials manuals for confessors emphasized the shame, the humiliation, and the potential for eternal damnation. Imagine a medieval priest delivering a sermon on the subject, his voice heavy with moral condemnation, painting a vivid picture of the victim's despair and the perpetrator's wickedness. But here's the really unsettling part. The church's concern with raptus wasn't always about punishing the perpetrator. It was often about restoring the victim, about ensuring her reputation and her ability to remarry. The focus was on the appearance of virtue, on the restoration of the woman's standing in society. A woman who had been violated, regardless of the circumstances, was often viewed as tainted, damaged, and incapable of leading a virtuous life. And this is where things get truly dark. The rhetoric surrounding raptus, the language of abduction, violation, and loss of virginity, began to overshadow the actual crime. A man might force himself upon a woman, but if she was abducted or if her virginity was somehow compromised, perhaps through a prior, illicit encounter, the accusation of raptus could be conveniently dropped. It's like a legal loophole designed to protect powerful men and maintain the status quo. The legal theorists of the time, like Glanville and Bracton, were acutely aware of this ambiguity. They recognized that the definition of raptus was so broad and flexible that it could be used to justify all sorts of abuses of power. Glanville, a particularly cynical legal scholar, argued that raptus could be used to control women, to ensure their obedience, and to maintain the patriarchal order. But the Church, despite its concerns about virtue and sanctity, largely accepted this interpretation. The emphasis on abduction and the loss of virginity became central to the legal and theological discourse surrounding rape. It's as if the act of violation itself was less important than the symbolism of violation, the image of the corrupted, violated woman. Consider the language used in the case descriptions. Instead of simply stating that a woman had been raped, legal writers often described her as being ravished, taken, or carried off. The word raptus itself became a shorthand for a profound and irreversible trauma. It wasn't just about physical harm, it was about the destruction of a woman's identity, her future, and her place in society. And the underlying assumption was chilling: a kingdom's safety and order depended on the chastity of its women. A woman's virtue was not just a personal matter, it was a matter of state. A king's right to control his wife's property, her dowry, her inheritance, her very life was inextricably linked to his right to control her body. This created a perverse dynamic. Actual rape, when it didn't involve abduction or the loss of virginity, was often ignored. The focus was on the narrative of violation, on the image of the corrupted woman, rather than on the facts of the case. Charges were routinely dropped, investigations were abandoned, and the victims were left with no justice. The legal system wasn't designed to protect women, it was designed to maintain social order and uphold the authority of men. And the rhetoric of rape, with its powerful symbolism of violation and corruption, served as a tool to achieve these goals. But here's the fascinating thing: despite the legal silence and the pervasive rhetoric of condemnation, the discourse surrounding rape also raised fundamental questions about the nature of violence, desire, and power. Philosophers and theologians debated the compatibility of rape and pregnancy, the possibility of marriage to the rapist, and the association of rape with the disorder of the kingdom. The language of rape, raptus, ravissement, and rap was remarkably consistent across legal and religious writing. This overlap reflected a shared understanding of rape as a form of theft, both of a person and of their potential. But it also revealed a deeper, more troubling connection between sexuality, power, and control. And what's even more unsettling is that these questions about consent, violation, and the construction of the female body continue to resonate today. The legal and religious debates of the medieval period laid the groundwork for many of the modern discussions about rape and sexual assault. The emphasis on the narrative of violation, the focus on the victim's reputation, and the tendency to prioritize social order over individual justice, these are all echoes of the medieval legal system. Think about it: the very concept of rape as a rhetorical strategy, the deliberate use of language to shape public opinion and justify abuse, is a direct descendant of the medieval legal discourse. The woman's violated body became an emblem of corruption, a symbol of the breakdown of social order. And yet, even in the midst of this condemnation, there was a profound lack of legal resolution. The victims were silenced, their voices ignored, their suffering dismissed. The English legal tradition, in particular, stands out for its distinctive approach to rape. Despite the influence of Roman law and continental thought, English legal theorists like Glanville and Bracton developed a sophisticated understanding of the crime, emphasizing the importance of consent and the distinction between rape and other forms of sexual assault. But even in England, the rhetoric of violation continued to dominate the discourse. The emphasis on the woman's loss of virginity, the association of rape with the disorder of the kingdom, and the tendency to drop charges, these factors contributed to a system that routinely failed to protect women from sexual violence. The early English legal discourse, it seems, possessed a unique cultural perspective on rape, one that was both informed by classical legal traditions and shaped by the specific social and political context of the time. This perspective, preserved in the penitentials and preaching manuals, suggests a surprisingly nuanced understanding of the crime, one that recognized the importance of consent and the potential for abuse. Ultimately, the story of rape in the medieval period is a story of power, control, and the manipulation of language. It's a story of how a seemingly simple crime, the violation of a woman's body, could become entangled with complex legal, religious, and social issues. And it's a story that reminds us that the fight for justice and equality is a long and ongoing struggle. The echoes of the medieval legal system, the emphasis on rhetoric, the neglect of victims, the prioritization of social order, continue to haunt our own legal and social landscapes. So let's ask ourselves one final, unsettling question. How can we ensure that the voices of victims are heard, that justice is served, and that the rhetoric of violation is replaced with a genuine commitment to protecting the rights and dignity of all women?